Welcome to the Judicial Committee of the Privy Council, where today we're hearing an appeal from the Court of Appeal of the Bahamas. The case is called FundHaven Limited and the Executive Director of the Securities Commission of the Bahamas. The appeal is concerned with procedural matters governing appeals in the courts of the Bahamas. The appellant is represented by Ms. Gail Lockett-Charles and respondent by Mr. Gawain Ward. I'm going to turn now to Ms. Charles to invite her to make her submissions. Ms. Charles.
Thank you, my lord. Good morning, good afternoon in the UK, my lords. I appear on behalf of FundHaven Limited, formerly AccuVest Fund Services Limited, and South American Investment Fund Limited. My learned friend, Mr. Gawain Ward, appears on behalf of the Securities Commission of the Bahamas. My lords, we have provided our written case, and my lords, this is an appeal against the Court of Appeal of the Commonwealth of the Bahamas. And my lords, the issue that arises in this appeal is whether the Court of Appeal was entitled to discharge or disregard the trial judge certification of the matter as involving a point of law of general public importance. My lords, the history of this matter is that the appellants filed an appeal against the decision of the judge, the trial judge, Justice Hepburn, to dismiss their appeal against decisions of the disciplinary committee of the Securities Commission, the Respondent, which had found them guilty of certain breaches of the securities regulations laws in the Bahamas. The appellants applied to the judge to certify points of law of general public importance. And there was a full hearing, which I appeared on behalf of the appellants, and Mr. Ward appeared on behalf of the respondents. A full day's hearing before the trial judge, where the question as to whether this appeal involved a point of law of general public importance was fully argued, and the trial judge at the end acceded to the application for certification. The trial judge thereafter signed a written certificate. There was some challenges with regard to the format of the certificate, and what happened subsequently was the registrar signed a certificate. So, my lords, there were three points of certification, if I might put it that way. There was the certification of the trial judge at the hearing, where she heard the arguments and determined that the matter ought to be certified as involving a point of law of general public importance. And that is evident from the transcript of the hearing before the trial judge. Then there was the certificate that was signed by the trial judge herself, also certifying the matter. And then there was a certificate that was signed by the registrar. All of these certificates arose out of the hearing, the contested hearing, and the application for certification. My lords, the appellant wishes to make 3 points. First, that the Court of Appeal was wrong to find that the judge had not certified the identified points of law, and we will seek to demonstrate that plainly she did so. Further, the registrar's certificate on her behalf was a valid certificate. My lords, the second point that we wish to make is that once a judge has certified an appeal under Section 21 of the Court of Appeal Act as involving a point of law of general public importance, The Court of Appeal's statutory function is to hear the appeal. It has no power in law to discharge the judge's certificate. And, my lords, the third point that we would seek to make is that even if the above is wrong, the Court of Appeal is entitled to entertain, and the Court of Appeal is entitled to entertain the question itself and to examine the judge's reasons for certifying and overrule them and substitute its own decision for the judges. My lords, we say that the Court of Appeal was wrong in this case to do so because the grounds of appeal did involve points of law identified by them, and those points did arise out of the judge's judgment, as she herself correctly identified. And my lords, we would start by taking the court. I think it is useful to look at Section 21 of the Court of Appeal Act, and because this is the framework which this appeal sits in, and that might be found at volume 2, page 500 and page 1520. So if I could just start there. And my lords, Section 21 says, any person aggrieved by any judgment, order, or sentence given or made by the Supreme Court in its appellate or revisional jurisdiction, whether such judgment, order, or sentence has been given or made upon appeal or revision from a magistrate or any other court, board, committee, or authority exercising judicial powers, and whether or not the proceedings are civil or criminal in nature, may, subject to the provisions of the Constitution and of this Act, appeal to the court on any ground of appeal which involves a point of law alone, but not upon any question of fact, nor of mixed fact and law, nor against severity of sentence, provided that no such appeal shall be heard by the court unless a justice of the Supreme Court or the court shall certify the point of law is shall certify that the point of law is one of general public importance. So, my lords, the question was whether the trial judge, having certified the point of law as one of general public importance, the Court of Appeal should have gone behind that and set aside, essentially, or discharged or disregarded the trial judge's certification, and then gone on a process of its own to determine whether the matter was one which ought to be certified or not, and then essentially substitute their view of things for the trial judge's certification. My lords, before going into the 3 points in more detail, I think it would be helpful to set out some of the factual history and statutory framework. I have it set out in my written case. I don't know if the court would find it useful for me to just briefly go over that. But my lords, this case arises in the setting of the Investment Funds Act 2003 of the Bahamas. And my lord, the Investment Funds Act is found at volume 3, and the relevant section that this appeal engages is section 2 of that act, and that is found on page 1530 of the bundle. So, and my lord, that what is relevant about that section and why this is so important is it defines what an investment fund means, what it is to be an investment fund. And my lords, if we look at that section, section 2, it says that an investment fund, it defines an investment fund, my lords, as a company, unit, fund, or partnership that issues or has equity interests in the purpose or effect of which is pooling of investor funds with the aim of spreading investment risks and achieving profits or gains arising from the acquisition, holding, management, or disposal of investments. But it does not include any such pooled investment funds where the holder of an equity interest does not have the option to redeem his equity interest or require the issuer to repurchase his equity interest. That is, it doesn't include closed-end funds. My lords, why this is relevant is because the nub of this matter is that South American Investment Fund was not carrying on any activities that would fit with the description of an investment fund. So it was not any of these things that are identified by Section 2 of the Investment Fund Act, but it had elected to be licensed, which is permitted by the Act. A company can elect to be licensed as an investment fund. And its license, it had allowed its license to lapse, but in the meantime, it had not been operating as an investment fund. It was an IBC that wanted to have a license, an investment fund license, but at no time was it operating or did it meet the description of what an investment fund is according to the Act. And my lords, in my submissions in the court below, I gave the analogy of a hotel that might choose to acquire a casino license. So if a hotel acquires a casino license and allows that license to lapse, but at no point is operating a casino, the question is, can that hotel, when its casino license lapses, be penalized for operating an unlicensed casino? And my lords, we submit that the answer is plainly no. And the analogy in this case is if an IBC elects to be licensed as an investment fund and then allows its license to lapse, is it then operating an investment fund in breach of the law? And we would say plainly not. And this is something that the Court of Appeal disagreed with, but this is the point of law that is engaged here. It is, how is this legislation to be interpreted? Is a company, once it's licensed, required to remain licensed forevermore, or risk being held liable for operating an unlicensed fund, even though it's not operating a fund because it doesn't meet these requirements of Section 2 of the Act? Or is it entitled to apply for relicensing if and when it chooses to do so because it wants to maintain that license feature? My lords, Section 3 of the Act introduces a general prohibition against unlicensed. Yes, my lord.
Could I just ask you, as a point of information, if I may, at this point, why would a fund like this choose to license itself? What might be the potential advantages in so doing, if it's not otherwise required to be licensed?
My lords, the only explanation that I can give for that from the record is that this IBC was owned by a South American family, and the sole asset was some vineyards in South America. And for whatever reason, they wanted to have what is described in the record as the level of sophistication where they would have a fund license. But at no time were they doing any activity which would amount to the activity of an investment fund. And my lords, the reality is that the legislation allows a company to apply for licensing. It allows an IBC to apply to have this license. And my lords, there's no presumption that because the IBC obtains a license, it is then operating. It might do so in the future, perhaps. It might have the license so that it can, if it chose to do so, operate a fund. But the point here is that it cannot be held to have been operating a fund in breach of law when it wasn't. All it did was apply for a license. So the Section 3 of the Act, which we find in the record at page 1541, sets out the prohibition against unlicensed activity. And it says, an investment fund shall not carry on or attempt to carry on business unless it is licensed as, and then it sets out the types of fund licensing that one might have. Now, and this goes to the question, my lords, I would like to invite the court to look at Section 7 of the Act, which is found on page 1543. And this goes, I think, to my Lord Burroughs' question in relation to the ability of a company to obtain an investment fund license, even if they are not carrying on the activities that Section 2 of the Act defines as an investment fund. And so Section 7 of the Act, which is on page 1543 of the electronic bundle, says a company, unit, trust, or partnership where the holder of an equity interest, sorry, just make sure. Yes, a company, unit, trust, or partnership where the holder of an equity interest does not have the option to redeem his equity interest or require the issuer to repurchase his equity interest may elect to be licensed by the Commission as an investment fund, and if it so elects, shall be from the date of licensing, shall from the date of licensing be deemed an investment fund for the purpose of this Act. So we see here where the Act introduces the possibility that a company that is not an investment fund may elect to be licensed, and from the and from the date of its licensing, it'll be deemed an investment fund for the purpose of the Act. My lords, the Act also provides for investment fund administrators, and this is where the first appellant comes in, FundHaven Limited, and in two categories, restricted and unrestricted. So by Section 13 of the Act, unrestricted fund administrators may themselves license funds under their administration as smart funds. And my lords, in the factual background of this matter, what occurred was that the was that South American Investment Funds Limited had previously had for an administrator a company by the name of Winterbotham, which had an unrestricted license, and that company had licensed South American Investment Fund Limited as a smart fund. When there was subsequently a change in administration, and so Winterbotham canceled the investment fund license that they had in their power as an unrestricted fund administrator issued. They canceled that, and what then happened was South American Investment Fund Limited applied to be relicensed by the Securities Commission, because the new administrator, FundHaven, did not have an unrestricted license, so it could not itself license South American Investment Fund. It had to apply for licensing. And it was when that application for licensing commenced that the problems arose, because the Securities Commission then turned around and said, aha, here you are not licensed, and therefore you're acting in breach of the law. And they took it as sufficient that the fund had at one point been licensed and then ceased to be licensed, and therefore in the interval was operating an investment fund contrary to law. And the entire the point of law, the important point, which is what Justice Hepburn was live to when she granted the application for certification. The entire point is that justified? Can you come to the conclusion that just because a fund was licensed at one point and then ceased to be licensed, it is in that interim operating contrary to law, even though it's not an investment fund? It's not carrying out any of these activities that would make it an investment fund and that would make it operate as an investment fund contrary to law. My lord, section 26 of the Act, which is found on record page 50 and 54, requires an administrator of an investment fund to use reasonable efforts to ensure that the investment fund does not carry on or attempt to carry on business as an investment fund contrary to the provisions of this Act. So when we look at what the obligations on an administrator are, it is to ensure that the entity is not carrying on business as an investment fund. And so when we consider what is business as an investment fund, we have to go back to the definition of an investment fund, because that's the only way that we can make that we can make sense of that. So it takes us always back to section 2.1 of the Act, which I referred the court to earlier, when the definition of an investment fund is given, and not to belabor it, but it requires that it issues or has equity interests, the purpose or effect of which is the pooling of investors' funds with the aim of spreading investment risk and achieving so forth. And my lord, in this case, there is no dispute that this was simply an IBC, an international business company, that held one asset belonging to this family, this vineyard. There was no pooling of assets. There was no spreading of risks. It was simply an IBC that had one asset and had elected to apply for licensing under the Act as it was entitled to do. So my lords, instead of relicensing the company after its unrestricted administrator canceled the license, the Securities Commission instead started disciplinary proceedings against the company for operating an unlicensed fund, when in fact it was never doing that. And there was no evidence to suggest it. And the only thing that the Securities Commission relied on to do this was the fact that it had once been licensed and then ceased to be licensed. And my lord, there's in the proceedings for certification before Justice Hepburn, there was an affidavit put in by the Securities Commission by Mr. Hilary DeVoe, and that affidavit, my lords, we submit makes it very clear what the error in reasoning was, because Mr. DeVoe in his affidavit, I'm just trying to get it to hand here. Mr. DeVoe in his affidavit says that the issue is you can cancel, but you have to notify the commission that of your intention to cancel. If I could just take the court to the affidavit, Hilary DeVoe, and just find it very quickly in the record.
I see there is an affidavit by Mr. DeVoe at page 1284, but I'm not sure if that's the one you're wanting.
Thank you, my Lord Reed. Yes, it's at paragraph 9 of that affidavit. And it says, the applicant's questions do not raise a point of law of general public importance, as it does not impact most funds and it does not impact licensing requirements as asserted by the applicants. Given that a company can surrender its license and therefore its status as a regulated fund, provided this is clearly indicated by the fund that elected to be licensed. So the Securities Commission somehow treats the question as to whether a company that is not by definition an investment fund in terms of the activities that it's conducting, but is rather deemed an investment fund by virtue of its electing to be licensed. Mr. DeVoe treats as relevant the question whether it clearly indicates an election the surrender of the license provided that it clearly indicates an intention to surrender. So, Melissa, we say that there's really nothing can turn on this question as to whether you are surrendering your license or whether your license has lapsed and you're seeking to be relicensed. The fact is you're not an investment fund by the definition of the Act, and you cannot be held as conducting activity contrary, investment fund activity contrary to law, simply because your license may have lapsed and you've applied for relicensing. So, my lords, the important point in the background, my lord, going back to our written case, is that South American investment fund structure and activities did not fall under the definition of an investment fund in Section 2. And therefore, we say Section 3 did not require SAFE, if I may use the acronym for South American Investment Fund, to be licensed. And my lords, as I previously stated, Winterbotham Trust Company, the unrestricted administrator, had licensed SAFE as a smart fund, and AccuVest was a restricted investment fund administrator, and therefore it could not license them. And when AccuVest was appointed as its administrator and informed the commission of this, AccuVest then sought to license SAFE, and it's during that period that the commission determined that SAFE had been acting, and AccuVest had been acting in breach of the law. And my lords, the disciplinary proceedings ensued. And my lord, the commission formed the view that SAFE had been operating an investment fund without a license in breach of Section 3 of the Act, because it had remained active but had not been licensed since March 2006, and that AccuVest had, in breach of Section 26 of the Act, and Regulation 17(1)(g, permitted SAFE to operate. My lords, the commission. Sorry, my lords. I need to mute my other computer. My lords, the commission put these points to AccuVest for their response, and my lords, in the judgment of the judge, if we look at paragraph 35 of the judgment of the judge, which is found at volume 2, page 631, it recites AccuVest's reply by letter of 17th August 2009 in respect of the contention that SAFE had been carrying on business as an investment fund without a license. So my lord, what it says is, SAFE is an investment holding vehicle for a family business located in Chile, which is an ongoing concern. Nothing SAFE does even slightly resembles the activity of an investment fund. And the family business has been doing what it does for a very long time, long before the creation of SAFE. The restructuring that introduced SAFE into the family's holding structure, which AccuVest Limited, our broker-dealer, SIA arm manages, could as easily have been accomplished using a straightforward IBC or a company in any other tax-favorable jurisdiction. What SAFE does in no way triggers the need to make application to the Securities Commission or other licensor for a fund license. It was simply the choice of the client, who desired a level of sophistication in their holding structure, to apply for registration of SAFE as a smart fund 005. To make the election to seek out this registration a violation of the securities laws of the Bahamas would surely thwart one of the primary purposes of the Smart Fund program. That would suggest that every venture out there that may wish to become registered in the Bahamas as a smart fund would run the risk of violating the Investment Funds Act by carrying into effect their desires. We are certain that this cannot be the intent. So it was at all times clear that this entity was not operating a fund within the meaning of Section 2. And that is not disputed. The issue is,
Charles, if you look at the next paragraph in the judgment, it rather looks as though that's not the way the case was presented to the Securities Commission tribunal.
Yes, my lords. Sorry, my lords, which paragraph does the court want me to look at?
I was just raising, you've taken us to the Mr. Nottage's letter of August 2009, but the judge, Justice Hepburn, in paragraph 36,
Yes.
is making the point that that's not how the case was presented to the disciplinary tribunal.
Yes, yes, my lords. So I mean, my comment to that, my lords, would be it doesn't speak to the point as to the certification of the point of law, my lords, because this is an issue when SAFE was before the tribunal. They sought to explain the delays in their application for licensing. So they sought to. There were personal difficulties with their personnel, and there were a number of issues that affected the delay in their relicensing application process. But my lords, at no time were they conducting activities as a fund, and that was always clear and accepted by all parties.
Well, you see, the judge then, I mean, obviously you know more about this case than I do, but the judge then, because the matter wasn't put in that way below and the supporting evidence wasn't produced below, she then begins a discussion of Ladd and Marshall, and at paragraph 37,
Yes.
and conclude at paragraph 41 that the evidence that would support that line of argument should not be admitted.
Yes, my lords. She did not allow the affidavit that they sought to put in to be introduced, my lords. My lords, when we come to the appeal, what we say on the appeal is that there was no evidence upon which the tribunal, the panel could have found that SAFE had been acting contrary to law. So while she didn't allow them to put in evidence that showed that they were not, really the burden of proof is on the commission to demonstrate that they were. And their evidence itself, the very letters that the commission relied on to find that SAFE was acting in breach, all those letters showed was an IBC seeking to be relicensed. So when you look at what the panel did and what the panel relied on, they simply accepted that this IBC was seeking to be relicensed, and therefore it must have been acting contrary to law, and there was no evidence that was before them that would support that. And so the question is whether they were entitled to make that assumption that in the absence of any evidence that this company is operating an investment fund, can we simply take the fact that it's applying to be relicensed and that it had been once licensed and is now seeking to be relicensed, can we simply take that as sufficient to say that it is acting in breach of law and its administrator was acting in breach of law? My lords, and we explain this in our written case, my lords, because notwithstanding that there was no evidence that the company was operating as an investment fund within Section 2 of the Act, the Commission lodged a formal complaint against AccuVest and SAFE and required them to attend a hearing before the panel of the Commission. And my lord, that complaint set out the alleged breaches. And I've already adverted to them, but they are in the record at page 1541. It is that SAFE was carrying on business without a license in breach of section.
Just before we go to 1541, before we leave the judgment, can I ask you about paragraph 60, which is on page 638, begins on 638.
Paragraph 60?
Yes. Yes, you'll see there it said that as regard the breaches against SAFE, Council's core submission was that SAFE was not a fund within the meaning of the IFA and so was not subject to the regulatory jurisdiction of the Commission. That submission was not put to the hearing panel. Is that right?
My lords, I think when we look at, I don't think that is correct. When you look at the information that the hearing panel had before it from the Securities Commission itself, it contained this information that the company was not an investment fund and was simply an IBC.
Yeah.
So
you see, she goes on to say later in the paragraph, the difficulty which Faceless got is that the evidence of fact on which a submission was based is only found in the affidavit, which I've ruled is not to be received. Without the affidavit, the submission that SAFE wasn't a fund within the meaning of the Act, and so was not subject to the regulatory jurisdiction of the Commission, are rejected. Yes, Lord Sales.
Well, in fact, I wanted to ask about that as well. As I read that paragraph and the judgment as a whole, the background was SAFE had wanted to be licensed as an investment fund for reasons of its own and obtained such a license. At the hearing before the judge, a reason was put forward as to why it wanted to be licensed, but that was by new evidence that wasn't admitted. Why wasn't the judge entitled to infer from the very fact that SAFE itself wanted to be licensed, that it wanted to be so for some sensible business reason, in that it was carrying on business as an investment fund, there being no other explanation that was put forward in admissible evidence by SAFE itself?
My lords, we would submit that the Securities Commission, before it can determine that a breach of the Act has been committed, must have evidence of that breach. And licensing and having your license lapse is not evidence that you are operating an investment fund. I think this goes to the.
I'm so sorry to cut across you there, but that's what I'm putting to you. Yes. Why, if SAFE itself wants to be licensed, isn't the inference that it wants to be licensed for some sensible business reason, namely that it is carrying on business as an investment fund? And absent any other explanation for that, why can the inference not be drawn that in fact it did carry on business as an investment fund?
Well, my lords, I don't think that an inference that a company is licensed means it's carrying on that business. I mean, surely a company can obtain a license before it actually starts to carry on the business, and that, that's sort of my casino example, if you would.
Well, one difference perhaps from your example is that by virtue of being licensed, it's deemed to be an investment fund. And an investment fund is defined as a company which carries on a particular sort of business. So it's deemed to be carrying on that kind of business.
But my lords, if it's going to be held as carrying on business by contrary to law, carrying on investment fund business without a license, we would submit that it's not deemed to be carrying on business as an investment fund. It's deemed to be an investment fund. So
then, if you look at the definition of an investment fund, it's defined as a business carrying on certain activity.
Yes, my lord, Reed. And the issue then would be when it is no longer licensed as an investment fund, does it continue to be deemed to be carrying on business as an investment fund, or does it continue to be deemed as an investment fund? It might be the case that when it's licensed, and under the law, when it's licensed, it's deemed to be an investment fund. That's accepted. But does that mean that it has to maintain that license forevermore? Or when it no longer has that license, is it no longer deemed to be an investment fund? And my lord, we would submit that that would be the logical continuation of that argument. If the company is only deemed to be an investment fund by virtue of the election to be licensed as an investment fund, then surely when it is no longer licensed, it is no longer deemed to be an investment fund. If that was the only basis upon which it is, it's not operating as an investment fund. It's only deemed to be an investment fund. And so by virtue of its licensing. And so when that licensing lapses or is surrendered or whatever, or canceled, as was in this case, why is it that it is still deemed to be an investment fund?
Perhaps it may be that it may be that a matter of law it's not, but that forms part of the background to, I mean, the obvious, as Lord Sales was putting to you, one might have thought that the natural inference from a body taking on a license is that it is planning to do what a license would deem it to be doing and is necessary for it to be permitted to do. Otherwise, why bother to get a license? And I mean, obviously, one could rebut that by leading evidence that after the license had lapsed, the company wasn't in fact carrying on any activities for which a license was necessary. But it looks as though there was no evidence to that effect presented.
My lords, I think that what we're getting into is the exact question of law that the learned judge certified.
Well, it's not really a question of law so much as to do with inferences of fact that can be drawn in the absence of contrary evidence.
Sorry, my lords. I mean, the question that the trial judge certified as a point of law, and we find it at the very end of our written case under paragraph 96, and it is whether by virtue of section 7(1) of the Act, a company that does not issue or have equity interests, the purpose or effect of which is the pooling of investor funds with the aim of spreading investment risks and achieving profits and gains arising from the acquisition, holding, management, or disposal of investment, can be considered to be carrying on business within the meaning of section 3 of the Act. And whether a company that was once but is no longer licensed by the Commission as an investment fund continues to be deemed an investment fund by virtue of section 7(1) of the Act. So I think, my lords, the entire discussion really underscores the point of law that the judge certified. And my lord, the question is whether the Court of Appeal was entitled to go behind that certification and substitute their own view of the matter. But my lords, I think one way or the other, this point arises from the appeal, and it is a point of importance, and it is a point. Yes, my lord.
Yes, if I may, I just wanted to pick you up on the way that you just put that, and indeed how you introduced the appeal. On my understanding, the Court of Appeal didn't, as you put it, discharge or go behind the certification by the judge. Their primary point was, reached earlier in the proceedings, that the judge had not certified on proper understanding any point of law. And therefore, because there wasn't a certification from the judge, the Court of Appeal turned its own attention to whether it should certify. So that the pattern, as I understand it, but I'm inviting your submissions on it, is that from the Court of Appeal's point of view and on its ruling, there is no certification by the judge. And therefore, the Court of Appeal looks at the matter completely anew for itself, not substituting its view, but just asking itself the question, is there a certifiable point of law of public importance?
Yes. Yes, my lord Sales, and if I may, I see two questions there. One, whether the Court of Appeal was correct in its finding that the judge had not certified a point of law of general public importance, and I'd like to address that first, and then secondly, whether it was whether its treatment of the matter was appropriate. So with regard to the first limb, I think that the answer, when one looks at the transcript of the proceedings before the learned trial judge, the hearing for certification, and when one looks at how the trial judge dealt with that, my lords, the answer is that clearly she did certify a point. And if I could take the court through that argument. My lords, the learned judge's first certificate is found at volume 3, page 1281. It's the first document in that volume. And what I would like to point out there, first of all, is the background to it. So what it says is, upon application by the defendant's appellants by way of summons filed the 4th of September 2013. So it's important to note that there was an application that was heard. Heard before Her Ladyship, Madam Justice Claire Hepburn, Justice of the Supreme Court, and upon hearing Gail Lockhart Charles of counsel for the defendants, appellants, and Gawain Ward of counsel for the respondents, and upon reading the affidavit of Keith Kelty, filed herein on the 4th of September 2013, and the affidavit of Hilary DeVoe, filed on the 27th of September 2013. It is certified by, sorry, my lords, this certificate is the one that was signed by the registrar. It is certified by Her Ladyship, Madam Justice Claire Hepburn, Justice of the Supreme Court, that the following points of law identified at paragraph 12A and B of the appellant skeleton argument dated the 19th of September 2013 and raised by the intended appeal, namely, whether by virtue of section 7.1, and those are the 2 points that I referenced in the, yes, my lord.
I'm so sorry. I think this is the first certificate as signed by the judge, isn't it? Although the order bears the registrar's moniker at the bottom, this certificate is framed as a certificate of the judge.
It is, but this was signed by the registrar. The issue was that the judge had demitted office by that time. So that was why the registrar had signed it.
I thought that the issue about the registrar signed certificate related to the second certificate, not this one. On my understanding, there isn't an issue, but that the judge signed or should be taken to sign this certificate. The difficulty with this certificate, as I understand it, is that it doesn't specifically identify a point of law as required by section 21. And one can see the point that was made by the Court of Appeal when they rejected this as a certificate. If you look at the grounds of appeal to which this order cross refers, which I think are at page 1361, and there is a long list of grounds of appeal, and the judge doesn't identify which, if any, of those specifically involved a point of law of general public importance, and that was the difficulty, as I understand it, with this certificate. But it might be helpful if we looked at the grounds of appeal to which this refers, which I think is 1361.
Yes, the second certificate, the one signed by the registrar, is at page 500, but it's a different document.
The two certificates are, one is at page 1278 and the second one is at page 1281.
Yes, 1279 is the same as the reference Lord Reid just given you.
Yeah.
So the grounds of, so I think my Lord Sales wanted me to address the grounds of appeal and connect them to the certificate.
Yes, because it was really making the point which I understood the Court of Appeal to be making in its ruling, that the first certificate did not qualify as a certificate as required by section 21, that the grounds of appeal to which it cross refers are 16 points of appeal, and the certificate fails to identify which of those is a point of law of general public importance. It just refers compendiously to the whole of the grounds of appeal.
All right. Yes, my lords, and if I will do that, but I'd like to do it in the context of section 21, because I think it's important to note that Section 21 speaks to it involving a point of a point of law of general public importance. My lords, if the court were to find that my lords, if the court, the first ground of appeal speaks to says that there was no evidence before the disciplinary committee or the court to prove that the first appellant, SAIF, was an investment fund within the meaning of the Investment Funds Act. And my lords, that ties directly into this question of deeming or whether the fund is operating as a pooled assets to share risks and so forth, or whether it can simply be, whether they can accept without any evidence that it is operating as an investment fund within the meaning of the Act, that simply because it was licensed, it's deemed to be, and therefore it is, and therefore if the license lapses, it breaches. So that's how the first point involves the question of law of general public importance.
But I'm so sorry.
Section 21, it's necessary to identify a pure point of law, and the whatever its merits, the first ground of appeal isn't posing a pure point of law.
My lords, if the commission or the panel can, on no evidence, make a finding that the company is operating in breach of the law, my lords, we would submit that that is a point of law.
But isn't there the difficulty that I've already raised with you in relation to that? The judge in her certificate does not say ground of appeal 1 raises a point of law of general public importance, or ground of appeal 3 does so. In her certificate, she simply refers to the whole of the grounds of appeal and says they involve, without identifying which one is the point of law of general public importance, which she is certifying. That's as I understood it, was the problem that the Court of Appeal had with the first certificate, that I failed to identify out of the menu of 16 points which was the point of law of general public importance. And perhaps I could ask you, which do you say it is?
My lord, we would submit that the grounds of appeal, when taken as a whole, involve a point of law of general public importance, because once the court addresses its mind to the question as to whether a company once licensed as a investment fund then will continue to be deemed as an investment fund. If the answer to that is no, my lords, then there was no basis upon which the Securities Commission disciplinary panel could have found SAFE guilty of these breaches. So if we look at the grounds of appeal, my lords, the second one, the learned judge erred in finding that the disciplinary committee was entitled to find that SAFE and AccuVest were guilty of the breaches alleged in circumstances where there was no evidence before the disciplinary committee or the court to prove that SAFE was an investment fund within the meaning of the Investment Funds Act. So there was no evidence to demonstrate that they were. They simply relied on the fact that it had once been licensed as evidence that it was conducting this activity and therefore must be in breach of the law. Yes, my lord.
that doesn't exactly jump off the ground of appeal. Someone just coming fresh to this case to find out what was meant by the judge's certificate wouldn't think that ground one necessarily involved a point of law at all. It might simply be a complaint that if you look at the evidence, none of the evidence proved what had to be proved. And I should say that I'm not just confining that observation to ground one, because every single of these grounds is about evidence, I think, for 7 and 10, and they're simply about the conclusion reached by the court. I'm on page 13612.
Yes, my lords, before going to ground 7 and 10, might I just, because I think it would help if we looked at ground 3, and if we looked at that together with paragraph 63 of the judgment. So ground 3 says that the learned judge erred in finding that the correspondence passing between the Commission and SAFE was evidence capable of proving that SAFE was operating as a fund within the meaning of the Investment Fund Act 2003. And that ties into paragraph 63 of the judgment.
I'm so sorry to pick you up on this, but it is an important point. Isn't the point of certification that one can see clearly from the certificate what the point of law of general public importance is, so that the whole of an appeal can be focused on that point, and to spare the court, ourselves included, from the sort of paper chase you're inviting us to carry out, of looking at something which is imprecisely defined in the grounds of appeal, going back to the transcript, and then coming back to a certificate, as I assume you will do, which itself is imprecisely defined, and then saying, well, if you put all these things together, you can say that there is a point of law of public importance which has been certified. Isn't the point of certification to avoid any such paper trail and to provide a clear definition of the point of law of public importance for the appeal?
My lords, the case law does not support that, and I would take the court to the cases that we refer to as to make good that point. My lords, as I see it from the case law and also from the reading of the section, the point of certification is that the trial judge, as the gatekeeper of matters that are suitable to go forward to the Court of Appeal, must give it certification before it can proceed. Once the trial judge does certify it, then it is entitled to proceed, and that's the very issue that underlies this appeal.
Certainly, but don't the parties and the appeal court need to be able to look at the certificate given by the judge and know clearly what the appeal is about? The judge may not be around anymore to define it further than that. One's supposed to be able to tell that from the certificate. Isn't that right?
Well, my lord, if what the act does not, the act doesn't say that, my lord. The act says that it involves a point of sorry. It says that an appeal to the court on any ground of appeal which involves a point of law alone, but not upon any question of fact, nor mixed fact and law, nor against severity of sentence, provided that no such appeal shall be heard by the court unless the justice of the Supreme Court or the court shall certify the point of law as one of general public importance. So it's an appeal that involves a point of law, and it has to be the point of law that's involved has to be certified. Well, we say that this appeal clearly involves the point of law that the learned judge certified, and she did certify this point of law. And if the Court of Appeal my lords, we say that the cases show that if the Court of Appeal does not agree with the judge's certification, it nevertheless must go on and hear the appeal because the judge has certified it as involving a point of law of general public importance. My lords, if I could take the court to just ground 3, because I think it really does connect a number of things. Ground 3 says that the learned judge erred in finding that the correspondence passing between the Commission and SAFE was evidence capable of proving that SAFE was operating as a fund within the meaning of the Investment Funds Act. And that's really the key issue. And if we look at paragraph 63 of the judge's ruling, she says, I am satisfied that
Can I have a page?
Sorry, my lords, page 640, volume 2.
Thank you.
She says, I am satisfied that PS3 to PS12 is evidence on which the panel could make its findings of guilt of SAFE. The evidence is that AccuVest elected to be registered in 2004 when it was being administered by Winterbotham. The application to the Commission in 2007 was with respect to the relicensing of SAFE following the transfer of administration from Winterbotham. In response to breach 2 against AccuVest, Mr. Nottage told the panel that at the relevant time, SAFE was either a smart fund and held a license or was in the process of registering as a smart fund once the administration services transferred to AccuVest. SAFE was licensed as a smart fund when it elected to become registered as a fund under Section 7 of the Act in 2004. And once it elected to become registered, it could not simply choose not to be registered, particularly if it did not inform the Commission of its decision. So this was the material finding here. There was no evidence that this company was operating as an investment fund. The court concluded that made this legal pronouncement of law that once it elected to become registered as a fund under Section 7, it could not simply choose not to be registered. That is an interpretation of the Act, and it is a very important point of law, because if this is the case, then any company that chooses to be licensed as an investment fund, whether it's carrying on these activities of a fund or not, if it elects to surrender its license or let its license lapse or no longer apply for relicensing, it's at risk of being held to be not allowed to do that. And the Act, there's nothing in the Act that speaks to that. And this was the reason that the Securities Commission held that SAFE and AccuVest were in breach. And this is what, yes, my lord.
Yes, paragraph 63 runs together a number of points, but as it seems to me, the key ones seem to be SAFE chose to ask for a license in the first place, and the explanation for that by way of new evidence was not admissible before the court. It was known that it was trying to relicense itself. Again, no underlying business reason given for that. Inference, it might be said, it wanted to be relicensed because it appreciated that it was operating as an investment fund and needed to be licensed. And then Mr. Nottage, who I think is AccuVest, isn't he? He told the panel that on one view, SAFE actually was a smart fund at the relevant time. Whereas your whole case now is that it was only ever in the process of registering as a smart fund. But he seems to accept, well, perhaps it was a smart fund. But I'm slightly struggling to see why, just as an inference of fact, forget about points of law, it couldn't be drawn from these evidential elements, the inference that in fact it was carrying on business as a smart fund.
Well, my lords, when one looks at the at PS3 to PS12, which is which are the documents that the court says were was the evidence that the panel could make its finding of guilt. When one looks at those are simply correspondence with regard to providing information for relicensing. So there's nothing, and I appreciate that we're not allowed to appeal on questions of fact, and nobody is seeking to do so. We're accepting the facts as this correspondence existed, and nobody is disputing that. The question is, as a matter of law, was the panel entitled to make that inference, if we want to call it that, that a company is operating in breach of the law when they have simply been deemed to be an investment fund because of their licensing.
Am I right in thinking that Mr. Nottage is AccuVest, is from AccuVest?
That is correct, yes.
So why, when he says, in effect, states either was a smart fund or was in the process of registering, could that not be taken to be an admission or partial admission against interest?
Well, I think, sorry, I think what it means, what he's referring to is that when they were under Winterbottom, they were a smart fund because they were licensed as a smart fund. And then they were in the process of relicensing. So it's when they are licensed, they are deemed as a fund. And then when they are relicensing, they are in the process of licensing. That's what I understood that to mean.
All right, thank you.
So my lords, when we look at,
I appreciate you've been answering quite a lot of questions over the last few minutes, but you're going to have to complete your submissions quite shortly because we're getting behind time here.
yes, my lords, could I perhaps then just wrap up this point, which I think addresses the question as to whether the point of law has been identified, whether it's connected to the appeal, to the grounds of appeal, and when you look at ground 3, and when we look at that in conjunction with paragraph 63 of the judgment, it brings into sharp focus the point of law, which is what we've been debating during this appeal itself, which is whether there can be an inference, and whether that inference that a company, just by virtue of it being licensed, means that it is operating as an investment fund in circumstances where it's no longer licensed. So that is the actual point that the judge identified, and we say that this appeal, the section 21 of the Act requires that the appeal involve a point. So the judge has to certify the point that the appeal involves. I don't think that I don't think it can be disputed that this appeal involves that point when one looks at the grounds and when one considers just the nature of this entire discussion here today. It's clear that it centers on how is this act and this deeming provision to be interpreted. Is it enough to simply say, in the absence of anything else, that the company was licensed, therefore it must be operating as a fund, therefore it's operating contrary to law because it no longer has a license? I mean, it really puts a company into a catch into a, we would submit an untenable situation. And it's certainly not anything that's contemplated by the Act, so it could only be an inference, and I would submit that there needs to be clarity given to that, and this is what led the judge to conclude that the point of law that this appeal involved was one of general public importance. My lords, if I could just take the court very quickly, conscious of time, to the cases. The authorities. Now, there are no authorities on this point in the Bahamian court, reported authorities that we could find, and the respondent has not put in any either. So I'm assuming that there aren't any. So, my lords, we have relied on UK authorities that we were able to find on similar sections regarding certification, and I just take the court to them very, very quickly. My lords, the English authorities show that once a certificate has been granted, the Court of Appeal has no power to set it aside or disregard it, even where it considers that it was wrongly given. And if I could take the court to the case of Harris, which is in the authorities volume at page 1709. Very quickly. And this was a case where the English Court of Appeal heard and determined an appeal, even though they said at paragraph 4 that they disagreed with the certification. So if we look at paragraph 4, what they say is, having granted a certificate at the September hearing, the judge went on to grant the appellant bail. For reasons that will become apparent, we do not think it was appropriate for the judge to have granted a certificate in this case. It is only in exceptional circumstances that appeals come before this court by way of certificate from the trial judge, rather than on the ordinary process of leave being granted by members of the court. A certificate would ordinarily be granted if there was very clear reason for doing so, such as an unresolved issue of law or where there were clear reasons for supposing that the appeal was likely to succeed. It is of some concern that in granting the certificate, the judge expressly declined to give any view as to the substance in the grounds of appeal advanced by Mr. Parrish. Further, the judge did not seek the assistance of the prosecutor as to the ground advanced, namely inconsistent verdict. Had he done so, it may very well have been that Mr. Parker QC would have been able to explain to him why the appeal was extremely unlikely to succeed. So this is a case where, and there is frequently found that the appellate court doesn't agree with what the judge has done, or the way that the judge has done it in granting the certificate, but it doesn't intervene or disregard the certificate. Then the next case that I would like to refer to is Mortlock, and that is found at page 1726. Going as quickly as I can. And if we just look at paragraph 2 of that, we see what this was about. It was the appellant was appealing against sentence by leave of a trial judge's certificate. So that's clear from paragraph 2. And then if we look at, I'd like to take the court quickly to paragraph 13, where the court says, we conclude by noting that the judge in this case granted a trial judge's certificate We do not take the view that this was an exceptionally difficult sentencing exercise. It may have been a difficult exercise, but sentencing courts are faced with difficult sentencing exercises every day of the week. None of the 3 members of this court has encountered a certificate granting leave to appeal by a judge in relation to a sentencing decision. The power to grant such a certificate does exist, but it should be exercised in the most exceptional circumstances. In our judgment, the present case was far from being such an exceptional case, and the judge should not have granted a certificate. It is plain from the papers that are before us that the Section 31 judge would not have granted leave to appeal in the present case, but her hands were tied because the sentencing judge's certificate had been granted. For the reasons given, this appeal is dismissed. So this case points out that just the level of deference that's given to a certificate when a judge exercises their power to grant the certificate, and it's very clear that that Justice Hepburn had the power under the Court of Appeal Act to grant the certificate. She heard arguments, and I would ask the court to have regard to the arguments that the judge heard, and to her reasoning, and to the transcript, because clearly she considered it something that she would certify, and she did certify it. And the cases show that when that is the case, we say that should not be interfered with. The other cases, my lord.
If you have any other authorities, simply give us the reference, because we're
Yes, my lord.
Mr. Ward's time now.
Yeah, my lords, the case of DeGorsey and Revenue Customs, my lords, which is at page 1665 of the record. And my lords, we would just again point out that this case is another one where there may be disagreement as to whether a certificate was granted or properly to have been granted, but the court did not interfere with it. And we'd also refer to Reed Pendleton, which is at page 1731 to 1732. My lords, we set these out in our submissions.
Yeah.
So my lord, I think I'm out of time, and so I would rely on our written case, unless there is anything else that the court would like me to answer.
Well, thank you very much indeed, Ms. Charles. I think it would be a good idea for the board to have a brief discussion of where we've got to before we call on Mr. Ward. So we'll go into a private meeting for a few minutes as soon as our engineer can get that organized. I think we're now ready to resume. Ms. Charles, we're most grateful to you for your submissions, but we don't find it necessary to call on Mr. Ward to reply. We'll now, in due course, tender our advice to Her Majesty, and for the moment the court will adjourn. Thank you all very much.
Thank you, my lords.
Thanks, my lords.